So I want to look now at the offence of assaults on emergency workers, and this is created by the Assaults on Emergency Workers Offences Act of 2018, and it involves a common assault or battery on a certain classification of staff. So an emergency worker is classed as anyone who works in custodial institutions such as secure training centres, removal centres, prisons, escort functions, custody officers, the NHS services, so your NHS health services or supported services of the NHS. So that will include mental health unit staff, A&E staff. So it's your frontline staff basically. Fire and rescue services, so staff working in the fire search and rescue role. Police officers or police support services, so the likes of your police community support officers. National Crime Agency officer. But a key thing is that the member of staff is acting in the exercise of functions as such a worker. So we're going to have a look a little bit more at what this is. So when we're looking at the assault side, it's either a common assault or a battery that the person does. So common assault is defined by Section 39 of the Criminal Justice Act of 1988. And an assault is any act which intentionally or recklessly causes another to apprehend immediate unlawful violence. So you don't actually have to hit someone for it to be an assault. It's the apprehension, so it's the thought process, where the battery is the actual physical contact. So a person intentionally or recklessly, and that's a subjective test, inflicts unlawful force on another. So you've got to prove it was unlawful force that they used and that it was intentional or reckless. So issues that come into that is the likes of the mental capacity factor anyway, in relation to intent, or the recklessness, because the recklessness, you've got to be able to demonstrate that they had some knowledge. And then whether the force was unlawful. So self-defense, for example, is lawful use of force. So if the patient, prisoner, detainee can demonstrate that they were acting in self-defense because members of staff were acting not in accordance with their duties, or the members of staff were actually assaulting them, then they're acting in self-defense. Now, CPS prosecution guidance on this offence states, the guidance sets out considerations for prosecutors and the police following the coming into force of Assaults on Emergency Workers Offences Act 2018 on the 13th of November 2018. The Minister of State at the Ministry of Justice set out the underlying principles of the 2018 Act as follows. An assault on any individual or citizen in our society is a terrible thing, but an assault on an emergency worker is an assault on us all. These people are our constituted representatives. They protect society and deliver services on our behalf. Therefore, an attack on them is an attack on us and on the state, and it should be punished more severely than an attack simply on an individual victim. Now, acting in exercise of functions as an emergency worker, the Act does not provide a definition for acting in the exercise of functions as an emergency worker. Prosecutors should identify and, if necessary, obtain evidence of what the emergency worker was doing at the material time to address this element of the 2018 Act provisions. The Act does not require the worker to have been acting in the circumstances of an emergency. It requires that the worker to have been acting within the functions of the type of worker the victim was, as provided by Section 3. Now, in January of 2020, there was a joint agreement drawn up in relation to offences against emergency workers. So this document sets out the agreement on offences against emergency workers between Her Majesty's Prison and Probation Service, NHS England, the National Fire Chiefs Council and the National Police Chiefs Council and the Crown Prosecution Service. So what is the level of culpability of the suspect is included in this document. Prosecutors should also have regard to whether the suspect is or was at the time of the offence affected by any significant mental or physical health or disability, as in some circumstances this may mean that it is less likely that a prosecution is required. However, prosecutors will also need to consider how serious the offence was, whether the suspect is likely to re-offend, and the need to safeguard the public or those providing care to such persons. Mental or physical health, accordingly, does not determine that no charge may follow. At the public interest stage, the focus is on, firstly, whether the suspect is or was affected by a significant health issue, and secondly, balancing that with seriousness, reoffending and safeguarding as relevant factors. Now, a couple of examples I'm going to give you here. So these were real cases that I was engaged for, and it was looking at whether the staff member was acting in the exercise of their duties and whether the force used against them was lawful or unlawful. So here's a rough explanation of it. So we've got a voluntary patient at a mental health unit and they decide that they want to leave. The staff want them to stay to be assessed by the doctor who's currently doing other rounds. The patient decides they don't want to remain any longer and they attempt to leave the unit. Staff decide to physically stop that patient from leaving and the patient uses force to try to leave. The staff overpower the patient and detain the patient in a room until the doctor arrives. Several members of staff and the patient are injured as a result of this use of force. The doctor's assessment is conducted and the doctor decides that the patient can leave as there's no grounds to section them. So the question then is, was the patient acting in self-defense against unlawful use of force on him? And bear in mind as well, there was no actual doctor's holding powers in place under Section 5.2 of the Mental Health Act of 1983. So the prosecution was commenced for assault on the staff by the patient. However, after submission of my report, the case was withdrawn prior to any court appearance. A second example of a case on this topic that I was involved in, the police were trying to move on a group of people on the public highway, so at Town Centre Street. There was no violence offered by the members of the public that the police were trying to move on. It was pretty much just a typical drunken set of people but there were no violence from them. One of the police officers uses numerous acts of force against the member of the public, such as pushing him, lifting him up, pushing him over, taking him to the floor. Eventually, the member of the public lashes out at the officer during one of these use of forces. The member of the public then is arrested in relation to the assault on the emergency worker. So the question there is, was this actually self-defense by the member of the public, which was against unlawful acts of force used by the officer on the member of the public? So again, the prosecution had commenced with assault on the emergency worker case, but then following submission of my report, the case was withdrawn prior to any court appearance. So the key thing here for you is to ensure that the de-escalation skills are your best friend to try and avoid use of force, because one aspect, if you do use force, one of the factors looked at is, was the reasonable attempt in trying to use de-escalation, or was it unsuitable, as in the situation was far too rapid flowing? But if it's reasonable to try and de-escalate, then you need to try and de-escalate. And use of force should not be the first option. As we've already covered, it should be the last option, not the first option, unless the specific circumstances which require it.